We have Assemblymember Alejo who is here. And you have 3 items. Let's go ahead and start in file order. So we will be starting with file number 12, AB 555.
Thank you.
Good afternoon.
Thank you, Madam Chair. Assemblymember Reggie Jones Sr. was hoping to cut in front of me, but we didn't allow that to happen.
Oh, I'm sorry.
I would like to present this bill, AB 555, which extends and enhances the expedited jury trial program. It has always been the goal of the bill to make courtroom procedures more efficient, but to save time and money for both the litigants and the courts while preserving due process rights. The most recent amendments are in line with this goal, which make expedited jury trials mandatory for cases with the amount in controversy below $25,000. Now, before I go further, I'd like to recognize the concern of the opposition in making this program mandatory, and I would like to commend their willingness to work with my office and the sponsors to find a middle ground. Over the last week, my office has met several times with the opposition, and it is our hope that we will have proposed amendments that get us very close to an agreement. With that, I promise to continue working with all the stakeholders to find a middle ground. However, something needs to happen to help our courts better manage their caseload. The original expedited jury trial option was enacted in 2011 to help deal with the overloaded dockets that were a result of the major budget cuts and courtroom closures. The current voluntary procedure, however, has widely gone unused, only a couple hundred cases across the state, but this is despite the fact that parties who use the procedure have often been satisfied with it. It is our position that this new mandatory program provides ample protections to the parties and will help better serve justice. Again, I commit to working with the opposition as the bill moves forward, and respectfully ask for an aye vote, Madam Chair, and I have some folks to speak in support.
Well, that was quick. Very good. Thank you, sir. Well done. 2 witnesses, 2 minutes each. Good afternoon.
I'll try to be quick. Brian Cavatek.
You don't have to talk that fast. That's just what young people do. So we can...
Thank you for that categorization.
I think it's cause of that.
Brian Cavatek, former president of Consumer Attorneys of California. With respect to the way the mandatory nature of this bill is concerned, it only applies to limited jurisdiction cases, which are $25,000 or less, and $25,000 is not what it used to be. These are small cases. There are a number of exceptions that we have already worked with the opposition on to try to come up with. They're enumerated in the materials, and they're common sense exceptions, most of which are mandatory and automatic. There is a catch-all for the court in its discretion to order a case not to be subject to the mandatory nature. We are still willing to work, obviously, with the author, and very grateful for the author's hard work on this. We're still willing to work with the opposition, but we have to understand the opposition, because the one I heard certainly today is that there's now an objection if there's any claim for attorney fees for a case that involves $25,000 or less. That coming from the insurers is strange, certainly, because having done plaintiff's work for 25 years, I've never seen a third-party insurance case, an auto accident case, where there's an attorney fee clause. I don't know of any cases, bad faith cases, that would ever end up in a limited jurisdiction court where there might be a claim under White versus Western title for attorney's fees. And certainly when we're talking about consumer contract cases at less than $25,000, where there might be an attorney fee clause, it would be a good thing to put those cases into this mandatory nature. It would limit the amount of attorney's fees, and certainly the insurers and CJAC don't represent those kind of consumer contract interests. So we're willing to continue to work. We have to work with something of substance. We have to know what the opposition significantly is looking at when they talk about attorney's fees or other areas, because we have to know what we're addressing. Generally, those attorney fees don't affect my constituency, the people that belong to our organization, but sometimes they do in employment cases, and employment cases that are worth less than $25,000 might well benefit from being involved in this. In fact, I think they would. A couple other things to point out. We've already
very briefly
agreed to a 3-year sunset on this, and we've also agreed that with respect to general jurisdiction cases, they'd be accepted from this, and that would be a voluntary program. Thank you very much.
Thank you very much.
Madam Chair and members, Mike Belote for both the California Defense Council and the California Judges Association, both in support. As Mr. Cavatek noted, the sunset on the existing voluntary program kicks in at the end of this year, so something had to be done or that program, although underutilized, would go away. We actually wanted to go bigger. We wanted to go bolder here and be a little more aggressive in terms of getting to a small mandatory program with opt-outs that were carved out specifically for insurers. And they make sense, the kinds of things: reservation of rights by the insurer, an allegation of punitive damages, allegation of intentional conduct, risk of liability above coverage. These are things that don't belong in limited jurisdiction mandatory programs. So we've crafted this specifically so that it's fair for everyone. The experience with the expedited jury trial process, importantly, is that it's been outcome neutral. The outcomes on these are exactly as what they would be under the regular trial process. So it makes sense to try this and see if we can deliver that sort of efficiency to the court system.
Move the bill. Good idea.
Thank you.
All right, other witnesses in support, very briefly.
Chair and members, Dan Pone for the Judicial Council. We don't yet have a formal position, but we've been very supportive of any ways in which we can expand the use of this expedited jury trial program, and we look forward to continuing to work on any final amendments that
I
we
would
need
think
to take.
with the problems the courts are having, you'd come out with a very strong support position.
We just need
I
a
hope.
tiny bit more time to get there.
All right, well, I think this is an excellent idea. That's right. Justice delayed is justice denied.
That's right.
And I think this is just a great idea, especially the results seem to be even on both sides. I have been involved in cases that go on and on and on, and by the time you're done, you have used up everybody's time and money and patience. And when you've got a limited amount of money that's involved, even though $25,000 may sound like a lot, in today's world, that represents 10 hours of somebody's time. It just makes sense. And so I'm looking forward to hearing the opposition come in and say, with the amendments taken, we have removed our opposition, but maybe not. So with that, are there any other witnesses in support? Witnesses in opposition? Yes, and I want to also indicate that those amendments are not in this committee right now. They are going to be taken on the floor. Excuse me, an appropriation. So, but with the representations and the understanding that those amendments will be taken, that's what we're focusing on at this point. Good afternoon.
Good afternoon again, Madam Chair. Chris McKaylee on behalf of the Civil Justice Association of California. We are in opposition to the measure, but we are continuing to work with the author and sponsors as we have been. I think the author noted we've met in the twice in the last week or so and are trying to hammer out additional items. Because of the, we're still receiving feedback, we'd like to reserve the right to raise potential other issues. Hopefully, for Mr. Kabatak's sake, they will be substantive. Anyways, so one of, I don't know if anyone else caught that, Senator Morlock. But anyways, we're continuing to work with the author and the sponsor, and again, they have taken most of the amendments that we have raised, so we appreciate that very much.
All right, next witness.
Good afternoon, Madam Chair and members of the committee. My name is Kara Cross. I'm with the Personal Insurance Federation of California. We too have been pleased that we've been able to work with the author and the sponsors of the bill. Unfortunately, we were brought into the process rather late, and that would probably explain why at this point we still have to have an opposition and less amended position. But I do have some, I am encouraged and believe that we will be able to get there, and we do look forward to working with Assemblymember Alejo and with the sponsors, and we do want to thank Assemblyman Alejo for all his work on trying to get to a solution on this bill. Thank you.
I'm a little perplexed, I must say. Let's finish with the opposition, and then I have a question. Sure. Yes, sir.
Madam Chair, Armand Feliciano on behalf of the Association of California Insurance Companies. Propose unless amended as well for reasons already stated. Thank you.
Thank you.
Madam Chair and members, Ted Angelo with the Association of California Life and Health Insurance Companies, and we're opposed for the reasons already stated. Thank you. Opposed unless amended.
So the reasons already stated are what?
Well, I actually had some testimony to talk about the sunset provision, but from what I understand, it sounds like that's going to be agreed to.
Yes, so I'm trying to figure out what are the problems that are left?
There's several technical issues that we have proposed to the author and the sponsors. I think we are just about in agreement on all of them. But again, since we've really only been talking since I think last Thursday, it's just a very short period of time to get through, you know, a lot of changes to a bill.
So I guess what has me puzzled is this is you're working off a program that's been in place for 3 years. It's been very successful, as I understand it. You want to expand it to make it a mandatory program for certain jurisdictional limits. What is the problem?
Madam Chair, if I might, again,
please.
Mike Below. One of the issues has been cases where you may have small damages but at big risk of attorney's fees. And so we have been trying to address some statutory examples where attorney's fees may be awarded to a prevailing party by a judge pursuant to statute. And so that is one of the opt-outs that we've been discussing in good faith with the opposition.
Right. But the point was made that if you have an expedited process, discovery's expedited, the proceedings are expedited, you only have 3 or 4 peremptories, you're not, I mean, you have reduced the time of a case significantly, and the attorney's fees, almost by definition, would be significantly reduced as well. Am I missing something?
The limited jurisdiction cases, by their nature, by the rules, by the statute, have very limited discoveries, as I'm sure you well know.
Exactly.
And what we want to know is there a specific example out there of a specific case? But to think of all cases with attorney fees provisions being excluded from this is just so overbroad, it's bordering on ridiculous. I don't understand what the issue is. That's the problem.
So are we is that the impediment? Because I agree. I mean, I'm going to support this bill, and if you don't want to take an amendment that excises the attorney's fees, because I think you've reduced them by virtue of this.
The expedited process.
Yeah. So at any rate, okay. Any other witnesses enough that we got the opposition? Any other questions? No? All right. Okay, I think.
Moved that it's.
All right, the bill's been moved.
Quick.
Would you like to close?
Madam Chair, we're very close to working through these remaining issues, but this bill got through the Assembly Judiciary 10-0. It got off the floor of the Assembly 79-0. This is, I think, unanimously, that's rare. I think everyone agrees so far in the Assembly that this is the right thing to do, but we're still trying to work these technical issues out, and we're very close. Thank you, and I appreciate your support.
Very good. Thank you. All right, Madam Secretary, this is due pass to Senate appropriations where the amendments will be taken that have been discussed today.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg?
Aye.
Hertzberg, aye. Leno? Monning? Wachowski? Wachowski, aye.
All right. 4-0, that bill will be on call. We next have file item, is it 14, excuse me. 14, file item 14. Assembly member, please go ahead and proceed.
AB 675. So this, Madam Chair, I would like to present AB 675, which updates and modernizes the statute governing agreements between rental car companies and their customers. And I would like to accept the amendments outlined in the analysis. The main provision of this bill works to increase transparency in car rental pricing by allowing rental car companies to fully disclose to consumers all public taxes and fees levied beyond those already permitted. This provision of the bill would not change any consumer safeguards, including the requirement that a rental car company give the customer a total price upon purchase. The bill received unanimous bipartisan support in the Assembly Judiciary and near unanimous support on the Assembly floor, 77-1, and it has no opposition or respect for an aye vote.
Good afternoon, John Ross on behalf of the Hertz Corporation. This bill builds on hard work done in 2006 by Senator Leno, who's not here to get the accolades. But Senator Leno's bill provided that at the time you book a car, you get an out-the-door quote.
Somebody's mics.
You get an out-the-door.
Next speaker, please.
Next.
We'll try it again. Did you get an? No, it must be me.
That's not what I meant.
Yeah, all right. No, next mic. No, you get an out. Okay, let's get back to the matter here. So in 2006, now when you rent a car, you get a quote that tells you for 5 days the cost is going to be $322.21, and when you go to get the car, it's got to be $322.21. Couldn't do that in 1989 when this law was originally enacted, but with the advent of this thing called the computer and everything else, we can now give everybody an out-the-door cost. This bill builds on that by defining the term additional mandatory charges, which are the items we can now separately state as long as they're rebundled into the total price and quoted to the consumer in that way. It's a great bill, couldn't be better. Ask for an aye vote. Thanks.
Thank you, Mr. Ross.
Gene Urban on behalf of Enterprise. We too support it. It's been a Herculean effort by the committee staff, equally thankless too. But in any event, we support the bill. Thank you.
Thank you, Mr. Urban.
Afternoon, Teresa Cook on behalf of Avis Budget Group. Want to echo the very eloquent comments of both my colleagues.
Thank you, Ms. Clerk. Any other witnesses in support? Any witnesses in opposition? Final comment?
I have half a conflict. Mr. Ross's client.
That's terrible.
Half a conflict. Hurts.
Hertzberg, Iceberg, you know.
Half a conflict.
Would you like to close?
Thank you very much. Some people have their mics taken, other people have problems working their mics. But I respectfully ask for an aye vote.
I'll move the bill, Mr. Vice Chair.
We have a motion. So moved. Madam Clerk, why don't we take the roll?
The motion is to pass as amended to the Senate floor. Jackson. Morlock.
Aye.
Morlock, aye. Anderson. Hertzberg.
Aye.
Hertzberg, aye. Leno. Monning. Wykowski. Wykowski, aye.
Okay, we'll keep that on call.
3-0.
3-0. That takes us now to your final bill, which I believe is number 31, AB 1390.
Thank you. Yeah, thank you, Mr. Chairman. Last bill, I'm here to present AB 1390, a bipartisan bill that will bring new efficiency to the process of adjudicating water rights in groundwater basins. Before I begin, I'd like to agree to the amendments in concept as outlined in the analysis, and I look forward to working with you and this committee and all the staff on the service of process issue as this bill keeps moving forward. On that point, I would like to thank your staff for their commitment and their time in making this a better bill. When the governor signed the Sustainable Groundwater Management Act last year, SGMA, there was an interest in streamlining the adjudication process. This bill will work in conjunction with SGMA to do just that. For this reason, the bill has attracted 20 co-authors from both parties and both houses of the legislature. The goal of AB 1390 is to clarify core procedures that apply to comprehensive groundwater adjudications to reduce the time and improve the efficiency of the process, thus reducing cost and protecting individuals' rights. Specific provisions of the bill will encourage early settlement and avoid undue disruption of local groundwater planning. In much of California, management of groundwater resources will be made easier by the identification and quantification of local groundwater rights, the purpose of an adjudication. But that process is longer and less efficient than it should be. Making groundwater adjudication more efficient will relieve a burden on the courts, and at the same time, it clarifies groundwater rights, bringing a double benefit to the entire process. While the bill will make the process quicker and easier, we are under no illusion that adjudications can be made short and easy. However, this bill will certainly make the process more efficient while protecting due process rights for all those involved. This bill received unanimous bipartisan support throughout the Assembly and the Senate Natural Resources Committees. When we are currently in the process of working with the opposition, the administration, Judicial Council, and this committee to work out technical issues and concerns as the bill moves forward. I respectfully ask for an aye vote and have some folks to speak in support of this bill.
Thank you very much. First witness.
Good afternoon, Chair Jackson. Jack Rice with the California Farm Bureau.
Turn your mic on. Red button.
Oh, there it is. Good afternoon, Chair Jackson. Jack Rice with the California Farm Bureau Federation. We've worked a lot on this, trying to come up with procedural improvements to the bill, and that's what the focus of this 1390 is. It's strictly on the procedural aspects of it. It does have some novel components to it. The idea of a preliminary hearing is an effort to increase awareness and sort of provide a forum where it can be determined whether or not the comprehensive adjudication is the correct avenue for the issues in play. With that, we've made a number of clarifications to the rules, and it's important to recognize that these procedural changes are largely informed by what has occurred through the processes and other adjudications where it was sort of trial by error, and this takes the wisdom of those prior adjudications and really tries to clarify and lay out what can be a game plan for how a adjudication can go forward. one of the major concerns has been this due process issue, and that was well described in the committee analysis. And as Mr. Alejo indicated, we're going to work on those issues. So with that, I request your support for this bill.
Thank you. Next witness.
Thank you, Madam Chair, members of the committee. Lauren Hajic on behalf of California Citrus Mutual, California Fresh Fruit Association, California Growers Association, California Cotton Ginners Association, California Dairies, Inc., and Western Ag Processors Association, as well as other various agricultural commissions and associations in strong support. One of the reasons we're in such strong support is by streamlining these procedural issues of the current adjudication process, small landowners have a better ability to actively engage in the adjudication process. Besides the preliminary hearing that Mr. Rice brought up, there is also a draft answer that comes with the notice to parties that they can fill out and enter into the adjudication action without having to go out and hire an attorney, so that way they make sure their rights are preserved up front without that initial cost. Further, by streamlining the procedure, it minimizes the ability of parties to delay the adjudication procedure, thus allowing the basin to become managed in a better way more quickly. I also wanted to just quickly address some of the opposition's concerns with the new Section 848 of the bill, which has been said in the opposition that it will somehow circumvent the Sustainable Groundwater Management Act process. This was not the intent of that section. What this section came out of is discussions from the author's office and sponsors with the administration and stakeholders in how to address a current problem in the adjudication system. So currently, we need to preserve the integrity of the Sustainable Groundwater Management Act and the planning process, and also preserve the integrity of the court system. So that was an attempt to do so after various discussions with the administration. And with that, I would urge your aye vote.
Thank you very much. Other witnesses in support, just name and affiliation, please.
Good afternoon, Chair and members. Tricia Geringer with Agricultural Council of California in support.
Thank you.
Valerie Nera for the California Chamber of Commerce in support.
Thank you very much.
Madam Chair, Whitney Wiley with the Association of California Water Agencies. We are actually support if amended. We've been working with the Farm Bureau since last year, trying to get the language just right, and we are committed to continuing to do that.
Thank you.
Margaret Gladstein on behalf of Western Growers in support.
Thank you.
Good afternoon, Madam Chair. Karen Lang on behalf of the California Association of County Treasurers and Tax Collectors, with the amendment that the author is accepting today to remove us from the noticing requirement. We have no more concerns with the bill. We'd sent a letter around, so I just wanted to let you know our concerns have been addressed. We have no further issue with the bill. Thank you.
Thank you very much. Witnesses in opposition.
Testifying.
All right, and again, this is with the amendments that have been taken. So if you're still in opposition, please go ahead and proceed.
Good afternoon, Chair, members of the committee. Kyle Jones, Sierra Club, California, and also on behalf of California League and Conservation Voters in opposition. We had issues previously with Section 847 that those had been amended out. However, the recent addition of Section 848, we believe, causes concerns with the SGMA process. Right now, local agencies are forming and then preparing groundwater sustainability plans that will go in, that need to be completed by 2020 or 2022. We think that despite the streamlining, that any adjudication would be finalized after these plans are already created and put into place. Section 848 then allows for there to be a determination that the adjudication would make the sustainability goals. Our concerns with that are that no one in the existing adjudication action would necessarily have the interest of sustainability in mind when determining what their rights are. In fact, what most courts under the common law do is determine safe yield, not sustainable yield. So really what you're saying is that the court would have to then go above that, determine what sustainable yield is, and we're concerned that you're moving from a public process to a non-public process. Additionally, plans that are going to be developed by the local agencies are subject to State Water Resources Control Board oversight. We're concerned that if you that the language of Section 848 would remove the State Water Board from that determination, thus, and also remove any state agencies with technical expertise in groundwater from able to monitor what's going on at the local level. For those reasons, we urge your no vote.
Thank you. Other witnesses in opposition?
Members of the committee, Kathy Mannion, RCRC, representing 34 rural counties. With the amendments taken today, we do believe we're getting very close to the point where we will be able to remove our opposition. However, as they were accepted in concept, we do need and we would like to continue working with the author and then run things by, of course, our county councils in order to ensure that the due process concerns are taken care of, and then we just have a few little technical issues.
Do you share the concerns that were just articulated about moving from the SGMA process to the adjudication process?
No, Chair.
Yours are very different issues.
Yes.
Okay. Other witnesses, thank you. Other witnesses in opposition?
Debbie Orrs from Community Water Center, and on behalf of Clean Water Action, we share the similar concerns of my colleague from Sierra Club regarding Section 848, as well as we still continue to look for a fund to help small disadvantaged communities and small water systems participate in the adjudications actions, but we look forward to, we appreciate the author's recent amendments, including expanded notice requirements, and we look forward to continuing to work with their office so we can remove our opposition.
Thank you. Other witnesses here.
Good afternoon. Karen Keene on behalf of the California State Association of Counties. I'd just like to echo the comments made by my rural counterpart and indicate that we're very appreciative of the amendments that have been taken so far. Thank you.
Very good. Other witnesses in opposition? All right, seeing none, bring it back to the committee. Senator Wojciechowski.
Is there, I'm reading 848, is there anything that would stop the Water Board from joining the action? I mean, you've got this expanded process. You're trying to bring everybody in the world into the action. Why would the State Water Board, if they thought that their sustainability plan was or was going to be adversely affected, couldn't just join the action so they would be able to advocate for before the judge?
So we did not want to change the status quo. There was nothing to prevent that. That's just not an issue we were dealing with. That section was really intended to find a way to ensure efficient coordination. And in fact, one of the ideas that promoted that situation was when you had a GSA, the Groundwater Sustainability Agency, that put a plan together that they really liked and everybody really liked, that you could have that be sort of the stipulated judgment. And so this was an effort to make that more efficient. It was not intended to result in an escape route.
I think also in response, the question is that you can't join unless you have an interest, and unless you're an adjacent landowner, there wouldn't be an interest which would allow them to come in as a party or to be part of the process.
I guess I'm just thinking the state agency, which would have jurisdiction over that whole basin or whatever that was could, I don't.
Well, the State Water Board, though, might not be able to intervene unless it shows it has an interest.
Right.
So that does take it. I mean, part of the concern, and I appreciate the enormous amount of work that's gone into this and the enormous number of amendments that have been taken. And we heard this in Natural Resources, I think, and moved the bill along because of the work that was being done. And you've moved it very far along, except there is a question about, it seems to me that this issue, to be able to move it out of SGMA to adjudication, which also I think undermines a little bit of the effort being made under SGMA to get everybody sort of talking on the same page, if they're, for lack of a more simplistic view of this. And I wonder if you could address the concerns of the Sierra Club as articulated.
Well, to go off that point, currently an adjudication can be filed right now. And so if an adjudication is filed in a basin that is also subject to the Sustainable Groundwater Management Act, that does not stop the Sustainable Groundwater Management Act. That basin must still meet the timelines of SGMA and must still meet those goals, or the State Water Board will step in. So you can't get away from the SGMA process if you're in a SGMA basin. So what 848 was addressing is that if that happens, when you get to the end of an adjudication, you know, how to make sure that you're preserving the integrity of the SGMA process and what's been done, and in preserving the integrity of the court. And that's why DWR is allowed to weigh in, give a report, let the court know if the sustainability goals of SGMA are being met by the proposed settlement or physical solution. And then that way the court can make the determination, does this meet the goals of SGMA or not? This doesn't address what would happen if the court said no, because then you would still be technically under SGMA and under a court order. So that's not being addressed here. This is 848 just addresses what would happen when you get to the end. DWR weighs in, and it's found that the sustainability goals of SGMA are met.
But then it does allow the court to potentially override the SGMA process, and that's your concern. Is that correct?
Yeah. First of all, the DWR input is not mandatory. And then secondly, it would declare that the purpose of the act would be fulfilled and that the court had sole jurisdiction over the judgment. And we think that would preclude any future water board intervention should the judgment fail to actually live up to SGMA.
Do you agree with that?
I don't. No, that's not the direction we were trying to go.
So would you put in something and take an amendment that would clarify that that isn't the intent, perhaps dealing with your concerns about that issue? If that would be a potentially unintended consequence, if that's not the purpose of doing it, can you put in there that that would in no way preclude SGMA from the SGMA process after the adjudication process, or as part of it? I'm not exactly sure the language, but...
Madam Chair, as it goes to the next step, we will consult with your committee to try to work out some language to address that.
That would be, all right, I would feel better about that if we could do that. Would you be willing to continue working on that, or do you think it's just an inherent problem that can't be overcome?
We're always happy to continue to work with it. You know, at this stage of the process, it is kind of late, but, you know, going forward, we'd be happy to work with it.
Never too late.
It's never too late.
Never too late.
But I tell you, we try to address some of the concerns, and it seems like their goalpost keeps moving. New issues come up.
This is the last of the goalposts moving. Let's try to resolve this.
Exactly.
I know you've worked very hard on this issue. I really appreciate the work everybody's done. I think you're close. You're on the 5-yard line. So let's see if we can't get you over the goal line.
Thank you, Madam Chair.
All right. Any other questions? All right. A motion by Senator Wachowski. The motion is do pass as amended to a Senate appropriations. Please call the members.
Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? Hertzberg? Leno? Hertzberg, aye.
Where is Hertzberg?
Leno? Monning? Wachowski? Wachowski, aye.
Thank you, Senators. Appreciate it.
4-0, that measure will be on call. Thank you very much, Assemblymember Lejo.